in a little bit. And as we're starting, I just want to ask Andrew Schumacher from Georgia Cumberland to say an opening prayer for us.
Good evening, everyone. Thank you so much for joining. Thank you, Richard, for coming to just invite everyone to bow your heads and we'll pray. Dear Heavenly Father, thank you so much for this day of life. Thank you that we can gather together from all different places around the country, Lord, and we can learn more and we can grow together. Lord, as we go for a deeper dive into estate planning, Lord, I just pray and ask a blessing on Richard as he shares his expertise and knowledge that you've given him. And Lord, just fill us with your Holy Spirit, Lord, as we, each one of us, can choose to be good stewards, following your will and trusting you, Lord, in our estate planning. Lord, just guide the conversations. May we be enriched and bless our families. We pray and ask these things in Jesus' name. Amen.
Amen. Thank you so much, Andrew.
Mhm.
All right. So, welcome again to anyone who is just joining us. I am sharing my screen with you to give you some details on the event that we're having tonight. Andrew, can you see that? Can you let me know if it looks good?
Yep.
Good,
That's
great.
it.
All right. So, welcome to the deep dive into estate planning. If you are new to estate planning, or if you are a self-proclaimed expert, but you still have a few more questions, you are in the right place. We have a wonderful guest this evening who's going to be sharing his wealth of experience with us about this topic. And I think all of you are going to leave feeling a lot more confident and prepared to take on your own estate planning journey. So these events are hosted by a variety of conferences, and I'm going to introduce you to them now. The first one is the Florida Conference, and they have a beautiful new director joining them, and Adele is also here. I think we might have some other staff joining us as well, but these are their staff. And we also have staff from Kentucky, Tennessee Conference. Silka is with us today, and her contact info is on the screen. So, welcome to all of our members and friends from Kentucky, Tennessee. And from Georgia Cumberland, we have Andrew, who led our prayer. Nicole's not with us this evening, but all of their contact info is on the screen, and we'll share it again later as well. Thank you for being here, Andrew, and welcome to our members from Georgia Cumberland. And this is my conference, the New Jersey Conference. My name is Rachel Linares, and I am the trust officer here. My boss, Carlos, is the director, and our contact info is on the screen. We're very happy to welcome you to this wonderful constituency of conferences that work together to plan these educational events. And we have one more conference to share with you, Southern New England Conference. Welcome to all the folks from that region. And I don't know if we have Audrey with us today, but she is their director there, and you can see their contact info on the screen if you are from their region. So before we begin talking about our topic, we do want to let you know a little more about us as Plan Giving and Trust Services staff. We're certified by the North American Division, and that means that we have to go through a very intensive class and test to learn the basics of estate planning and wills, trust, powers of attorney, all the things you normally associate with it, but also tax and accounting and some other things that we need to know in order to guide the members and help folks like you to figure out what's best for you and your families. We are not attorneys or accountants, but we are more like your guides into this journey. And the division equips us very well to do that job. You should
More than
know
that.
that as a Seventh-day Adventist, you have some privileges of membership, and one of them is interacting with this wonderful department of Plan Giving and Trust Services because we provide a lot of wonderful services for our members. These are on the screen. I won't go through all of them, but some to take note of are free consultations with an estate planner or a trust officer, such as myself and my lovely colleagues here, free preparation of basic estate documents, free notary services, and free consultations.
I
So
can't
please
hear you.
consider taking advantage of some of those. If anyone else is having trouble hearing, you can let me know, but I'll just ask again to keep yourself muted throughout the presentation if you can. We will have time for questions after. So we want to let you know as well that in addition to the great topic we will cover today, we have a whole schedule of webinars for the rest of this year. So you'll see all of them on your screen. The very next one we are having is going to be April 28th, also a Tuesday at 6 p.m. And it's called What to Do When You Say, I do later in life. And this is for blended families, couples who got together later in life, and they might want to know what estate planning considerations do they need to keep in mind in their specific situation. So this is going to be a really useful but niche webinar for the people who need it. We're excited about that one. And we do want to share our contact info once again. This is the contact info for the Florida conference. They're the primary hosts for this webinar. So for those in Florida, you can use the code on your screen, or you can take a screenshot with your device so that you can get in touch with them later. And most of us will also be putting our contact info into the chat for you to copy and keep hold of if you're interested in taking advantage of some of the wonderful free services that our conferences offer. And we've also got the contact here. I'll leave it for just a moment for your other conferences, New Jersey, Southern New England, Tennessee, Kentucky, and Georgia. All right, and before we get into our presentation, I did mention that we are certified, but we're not attorneys, CPAs, or licensed financial advisors. Please keep your computer muted, and you can write questions in the chat throughout the presentation or unmute yourself and ask as we go through the questions portion at the end. So without further ado, I want to introduce our presenter who is joining us tonight from ADRA, and he's a very experienced attorney and trust officer. Richard Harrison is licensed in California and Arizona, and he holds degrees from the University of California, Irvine, Trinity International University, and has served as a trust officer, conference legal counsel, assistant director of a church-run summer camp program, and I think several other positions as well that aren't mentioned here. He's very experienced and has a wealth of knowledge to share with you. And a fun fact, he also enjoys games, problem solving, and puzzles, and he views estate planning and financial planning as a never-ending supply of unique puzzles. That is a very apt description for it. I don't know if I've heard it put quite so well, so we're in luck to have him tonight. He is passionate about helping ADRA clients and donors and people like you resolve these challenges. So Richard, I'm going to prepare the screen for you to share, and welcome. Thank you so much for being here.
Thank you for that introduction. See if I can get my PowerPoint up on the screen here for you guys. All right. Okay, there we go. We all see it?
Yes, I do. Thank you.
All right, excellent. Let's jump right in. We got to get all this through all this stuff in an hour, so we got to move quickly here. A couple of disclaimers for me. I am an attorney, but I am not your attorney, and none of the conferences that we're hosting today are in the states that I'm licensed in. So the contents of my presentation today are not to be considered specific legal advice for your situation. I'm going to be talking about some general topics. Most of the laws regarding estate planning are pretty similar across all 50 states. But when it's time to do your estate plan, you'll need to contact one of the qualified individuals who are hosting today to get in touch with an attorney in your jurisdiction. Okay, just want to mention that. All right, here's what we're going to talk about today. We're going to talk about what is estate planning, and in very general terms, it's just wealth transfer and death, right? That's literally what it is. It's how we transfer wealth from one generation to another. When you transfer wealth before you die, we call that a gift. And so that's a whole nother topic of conversation. But when it happens at death, it's estate planning. And how do we do that? Well, there's three ways, and we're going to talk about the three different ways that we do that today. The first is with absolutely no planning. And in the legal world, we call that intestate succession. And generally, we don't like that, and it's a bad idea because that means the government gets to decide what happens with your stuff and your assets. And generally, that's to be avoided. You can do some planning, and if you have a will, that's great. That's a good first step. And for some people, that's all you really need. But for others, you need to do good planning. And good planning is done with what we call non-probate transfers, usually through the method of a trust. And we're going to dive deep into what all of that means over the next 45 minutes or so. Okay. So here we go. Oh yeah. Let's talk about some vocabulary. Intestate means that you're dying without any kind of estate plan. If you pass away with no will and no trust, you have passed away. You're considered intestate, which is kind of Latin for without an estate. And that means that there's a plan already in place for you and your assets, which is set up by the government. Probate. I'm going to mention the phrase probate a lot. What that is the process by which the government determines who gets your stuff. Okay, that's the legal process of transferring that wealth to the next generation. And I should mention that even good planning cannot always avoid probate. I talk about probate like, oh, it's this government process, and that comes with a negative connotation. That's not always the case. Sometimes a probate can be a good thing because it's final, right? Once your assets have gone through probate, and we've closed probate, which is the close of probation is something that we Adventists learn a lot about. But once probate is finalized in an estate planning scenario, we're done. It's over, and you can't go back and change what happened or challenge what the decisions that were made. And sometimes that's a good thing.
I could hear myself without.
What?
Go ahead and mute somebody there. Go. All right. So let's talk about the first thing on our roadmap here, which is the government's estate plan that you already have set up for you. Congratulations. What this is it's all set up in the statutes of your state, right? So, and your state has something called a probate code, where the government has already said, okay, if something happens to you and you don't have a will, here's who's going to get your stuff. And generally, it looks a little bit something like this. If for married people, if you're in a community property state, which is mostly on the West Coast, it goes 100% to your spouse. And if you're in a separate property state, which is the rest of us, then that's kind of what your distribution would look like. It's on the screen there. If you have no children, it can go to your spouse, to your parents, to your siblings, to your nephews. If you have children, it gets split between your spouse and your children. If you have no spouse, then it can go to parents, siblings, and nephews. And the list goes greater than that. I mean, if you don't have a spouse, if you don't have parents, if you don't have siblings, they'll start looking for distant relatives. If you were used to be married, but your spouse is deceased, it could go to your in-laws. Nobody wants that. And so, this plan has already existed. The government has a plan for you. And so it's not ideal, usually for most people. Here's the list for single people. Issue means children of your body and adopted children. Your parents, issue of your parents, which is your siblings. Your grandparents are on the list. Yeah. Oh, and then there's the last thing. That's escheatment, which is a fancy word for if the government cannot find any people on the list to take your stuff goes back to the government. That's the final straw. Like if there is no one to inherit, your assets can be turned over back to the government, and really nobody wants that. Okay, so this is all to illustrate the importance of estate planning. Okay, you have no control if you don't create a will, or you don't create a trust, or you don't name beneficiaries of your assets. You do not have control over who's going to get your stuff, and this is a kind of process that will be followed to determine who gets your things, and so that's why we want to have a will. So let's talk about a will and the details of a will and why it's important to have one. Okay. A will only has some very simple requirements. Oh, got another mute mark there. All right. You need to have something in writing, a signed writing. You need to have something called testamentary intent. It's testamentary intent, and I'll talk about what that means. And that's it. And so a signed writing can be a lot of different things. Typically, the best thing to do is to go talk to an attorney, get the attorney to type something up, and then you'll sign that document in front of witnesses. That's the most ironclad best way to do it. But there are examples like of people who just want to write something down on a piece of paper and then sign it. That could be a will. It could happen. Um, the most crazy example that I've seen that was found to be an actual legitimate will was a guy. He was a farmer, and he was out working on his tractor in the field, and something happened, and the tractor fell on him. And he knew that he didn't have long to survive, and so he literally scratched in the paint. Everything goes to Ma, like everything to my mother, uh, and and then passed away shortly after. And when they found him, that scratching in the side on the side of the tractor was found to be a valid will, which is crazy. But let's not rely on something like that for our purposes. Let's go ahead and get it done in a formal way. Okay. Uh, let's see here. So the will also has to have it has to identify the people who are going to get the things that you're going to have. So those are called the beneficiaries, right? The people who are going to receive your assets when you pass away. The will needs to identify somebody who is to receive your stuff. It does no good if you have a will that just says, my name is Richard, and I want my wife to be in charge of my stuff, and that's it. My will needs to specify, I want all of my assets to be transferred to this person, whether it's my wife, whether it's my kids, whether it's my favorite charity. And that's what's called a testamentary intent, the intent to give your assets away. Okay. It also needs to identify you as the testator, that is the person who's making the will. And usually we also identify your different family members as well. That's important. Another aspect in the will that is usually included and very important if you have minor children is guardianship for your minor kids. In fact, a lot of people don't know this, but the appropriate place for you to nominate someone to be the guardian of your minor children, if something were to happen to you, is in your will. So a lot of people think, well, I'm young and I'm invincible. And I don't have a lot of stuff because I haven't accumulated a lot of wealth. So what do I need to have a will for? Well, if you have an opinion of who's going to take your kids if something were to happen to you, then the appropriate place for you to make that opinion known is in a will. So that's why it's important for young people as well as older folks to engage in this process, is because that's how you can make your wishes known about how your kids should be cared for if something were to happen to you. Okay. And then, of course, the will nominate a person to execute your wishes on your behalf. And we call that person the executor, or in some states, that person is called the personal representative. And so as part of that process, you will nominate somebody to execute these wishes on your
I
behalf.
should check that. Who is our executor?
Gotta meet once. There we go. All right, let's keep moving on. So now the question we're going to ask ourselves is a will the only tool that we need to have when we're engaging in this process? I'll tell you, it's critical to have. You should, at the bare minimum, you should have a will. But a lot of times, it's important to have some additional documents to make the process, to make sure that your wishes are being followed correctly and accurately, and also to make the process easier for your family. And so let's talk about some of those other options. Oh yeah, I kind of already said that, but it may be that for a very small estate, for an individual or for a couple who doesn't have a ton of accumulated wealth, um, one very big example is if you don't own a home, um, so then you may not need more additional documents. It is possible that a will might be good enough, but it's kind of tough to make that determination on your own. The best thing to do is to talk to an estate planning professional who can evaluate your situation and determine, the best document plan for you. Yeah, I kind of talk about that stuff. Simple distribution means, I leave everything to my kids or something like that, right? Like if it's a very simple plan for who's going to get the assets when you pass away, then a will might be good enough. But let's talk about probate process. Let's see if I have another. No, let's do that. When you pass away, if you only have a will, then generally in most cases, what's going to happen is after you pass away, the people in your life who you've kind of talked to and said, "Hey, you're responsible for taking care of this stuff when I pass away." They'll go and they'll look for your document. They'll look for your will, like the physical paper document, and then they'll have to go get authority from someone to be able to act on behalf of your estate. And the process for doing that is called probate. So what typically happens is your executor will take the physical document and they'll turn it into a court somewhere where you live, in a jurisdiction where you live, and apply for what's called probate letters or letters of administration. And what's going to happen there is a two-part test, right? First thing to do is the court is going to make a determination that the document that person submitted is a valid will and it's your will, right? Like there's a process by which the court says, okay, this document that has been presented to us is actually this person's will, like, and we're going to follow what's in this document. And then once that process has finished, then the next step is, okay, now who's the person who's going to be responsible for executing these plans? The executor, right? And then the court will appoint the person that you've nominated in your document, ideally, to be responsible for transferring the assets. And only at that point can that person go in and, let's say, sell your house or liquidate bank accounts or things of that nature. So that process can take time. Depending on what jurisdiction you're in, it could take years. If you're in places like California, New York, and some other areas where the courts have a backlog of cases that they have to deal with, that process can take a long time, and it can be quite complex. And a lot of times, the executor is going to have to hire a lawyer to help them figure all this stuff out, and that's going to reduce the amount of your assets that's available to go to your kids and to your favorite charity. And so if we can avoid that process, generally it's a good idea. And so we're going to talk about some strategies to avoid that process. Okay. Now, I should say that there are jurisdictions where the probate process is relatively simple, right? And there are some situations in some states have said if your overall value of your estate is under a certain amount of money, then you don't even have to go through probate. We'll just have your executors sign a document that says that they swear that they're telling the truth and they're going to distribute your assets pursuant to your wishes, and then the courts will allow them to just do that without going through a full formal process. But when I say that exists for very small estates, we're talking about like less than $100,000 in most cases. And most people, yeah. And in most cases, people have accumulated. If you have a home, for example, if you have a house, and you have a retirement account somewhere, or maybe you had a pension, the total value of your estate will, can very easily exceed $100,000. I encourage you to, check what the number for a small estate is in your jurisdiction. It varies wildly from state to state. So you'll need to check in with an attorney or with a professional in your state to know what that number is for you. All right, I'm going to move on. All right, so let's talk about, all right, so we've decided, okay, we agree we should probably do something to avoid that probate process if we can. Okay, so let's try to find the easy way to deal with this stuff. Okay, and the general like overarching term for this is non-probate transfers, and that includes a lot of different strategies that we're going to talk about. Okay, the one that you hear a lot about is a trust. Okay. The trusts are the most common solution for avoiding probates in most states. I can tell you, if you're in any of the states that I'm licensed in, if you own a home, if you own any kind of real estate, then you're going to very likely be going to be looking at a trust to help avoid a probate situation in the future for you. And in the states that I'm licensed in, like almost every home that you own is worth more than $100,000. And so you're going to get over that small estate number very quickly. Also, I can tell you that in many states, just the fact of owning real estate of any value will automatically trigger probate unless you use a tool like a trust. So that's something that you definitely want to consider in your jurisdiction. So a trust is very simple. A trust it acts similar to the way a company works, right? Like a company exists and it can own its own assets, right? Like a company can have a bank account, a company can own property, and it can operate on its own without, in its own name and not in the name of an individual. A trust is a similar deal. The trust can own property. The trust can open a bank account, and the trust can operate in its own name. And that's important because a trust can exist over multiple lifetimes. Okay, so the deal with a trust is you set it up while you're alive, and in most revocable trusts, we're going to use that word. I'll explain that in a minute. You set it up while you're alive, and you can put assets into it, and you still have all the control. It's essentially as if you own it in your own name. You still use your own social security number, excuse me, and it's treated as it's your property, but it's not in your own name. It's in the name of your trust. Okay, and then when you pass away, you put in the trust document language that says, okay, when I die, my son or my neighbor or someone that I know and I trust will be the next person in charge of that trust. And then they can follow the instructions that I put into the trust of what's supposed to happen with my property after I pass away. And because from a legal perspective, when you pass away, there's no change in ownership because the trust has owned those assets the entire time. The next person who's in charge of the trust can just go ahead and do those things without the supervision of any court or any judge or any process that the government has set up. That person has the authority to act on your behalf without court supervision. And that's pretty cool. That avoids all of that probate process that we talked about. Okay, let me dive into the details of that a little bit more. Okay, so the most common trust that we use for estate planning purposes is something called a revocable living trust. You may have heard that term before. Okay, revocable just means that if you change your mind, you can undo all of it. It's not permanent, right? You can put assets in, you can take assets out, you can change the document, you can get rid of the entire document. You have complete 100% control over what's happening with the trust and the assets that are in the trust. Okay, and that's really important. There are other kinds of trusts out there where you lose control of your assets, and there are good reasons to set those up. But the most common estate planning trust is a revocable living trust, and that's what we use it for. Okay, I talked about the Times Trust. Let me talk about some other non-probate transfers real quick before we do a deep dive into trust. Payable on death contracts sounds kind of grim, but what that really means is when on your bank account you can name a beneficiary on there or a transfer on death beneficiary. Um, it means that when you die, someone else gets the money in your account. A life insurance contract is a form of a payable on death contract, right? That's another way to transfer assets to another person without the hassle of going through probate. Okay, you now buying life insurance is a complex thing nowadays, and there's lots of salespeople out there who are trying to get you to sign up for all kinds of stuff when it comes to life insurance and annuities and that kind of thing. So definitely take your time and talk to a professional when you're dealing with that stuff. But that is a way when you pass away, a sum of money goes to somebody else and it goes outside of the probate process. Your retirement plan is also a non-probate assets. Now, it used to be 40 years ago that the average American, their largest asset in their whole estate was their home. That's not the case anymore. Now, our 401ks, our 403bs, our retirement accounts, our IRAs are our largest assets when we pass away. So that's important to consider when you're doing your estate planning on what your intentions are for what's happening with those retirement assets when you pass away. You do have the ability generally to just name a beneficiary on that account. And then when you pass away, your beneficiary can roll over those funds into either take a cash distribution from them or roll them over into their own personal IRA in some cases. Um, the challenge with retirement accounts are, unless it's a Roth IRA, the remainder of the retirement assets are fully taxable when they're distributed. And so without some careful planning, you could really sign your heirs up for a really nasty tax surprise if they just get a lump sum distribution from your retirement account and there's no other planning to go with it. So that's definitely something you want to think about as you're planning for this stuff. And then I also mentioned like
Yeah.
one strategy. Sorry, one strategy that is very common is to add a child or a third party onto your bank account while you're living. And while that is a common strategy because of the ease of giving access to funds to that third party person, there's some downsides to that. One area you might want to think of is if let's say your child or your trusted friend who you've added to your bank account gets into a car accident and is found to be at fault of that car accident and is now gets a judgment against them and they owe somebody a bunch of money. When that other party comes in looking for their assets, they might see, oh, hey, this person is listed as an owner of this bank account. And so now I'm going to go after that money as well. Okay, that kind of thing does happen, and it unfortunately happens somewhat frequently. So whenever you're thinking about adding a child or a trusted friend or any third party as a co-owner on any of your assets, the same thing can happen with if you add a child to the title of your house, for example. Whenever you're thinking about adding any kind of third party to the ownership of an asset that you have, that's something you need to consider. Is what are the downsides of having that third party on there? Okay. All right, let's keep going on trust. Oh, indeed. This is something I should talk about just briefly. There are more states every year that are creating these transfer on death deeds. 20 years ago, these were very rare. But now they are becoming more and more prominent. And it's a way of transferring real property, your house or other land, to someone else without going through the probate process. So I'm not going to talk too much about them. They can be a useful tool. We use them in Arizona, but it's a very state by state analysis on whether or not that's a useful tool for you. You should talk to your estate planning professional about it if that's something you're interested in, to determine whether or not that's even an option in your state. And if it is, what are the rules involving those kinds of deeds, to make sure that's something that you can use for your plan. Okay. All right. Like I promised, let's deep dive into revocable living trusts. Okay. Revocable living trusts need essentially three people to make it work. They need a settlor, which is the person who sets up the trust, who creates the trust. You need a trustee, who is the person who's responsible for carrying out the tasks that are listed in the trust. And then you need a beneficiary. And the beneficiary is the person who benefits from the trust, using the name in the definition. With the revocable living trust that you're using for your estate plan, you are all three of those things at the beginning of the trust. So let's say I decide I want to create a trust for my family. I'm the one who makes the trust. No, I'm not. When I say makes the trust, I'm not saying literally writes the trust. I'm the person who is legally saying I'm creating a trust, right? So that would be you for your estate plan. I'm also saying I'm going to be in charge of my own trust while I'm alive. So I'm the settlor, and I'm also my own trustee. And while I'm alive, the trust exists for my own benefit because I'm just putting my assets that I own in there. So I'm all three of these things while I'm alive. And then so even though a trust requires three parties, you can be all three of those parties during your own life. And then when you pass away, you name someone who's called the successor trustee. That's very important, right? So with the will we talked about, you named your executor who's going to execute all of the tasks that are in your document, right? With a trust, the person that's going to execute the tasks that are in your trust is called a trustee. And so you can be the original trustee, and then you name a successor trustee to execute the document after you pass away. Okay. And then also you'll also name beneficiaries. We call them residual beneficiaries for the most part. And those are the people who get your stuff after you pass away. Those are the folks you name. Okay, I'm going to leave, all of my assets, 90% of my assets to my children and 10% to my favorite charity, for example. Or I'm going to name, leave some money to my church or something like that. And so that's who the beneficiaries of the trust are. Okay, you need all three of those things to set up a trust. But the great thing about a revocable trust, like I mentioned before, is all these things can change during life, right? Like while you're alive, you can, let's say you've named one child as a successor trustee, but you've decided, okay, for whatever reason, I don't think that's a good idea anymore. I want to name my other child as successor trustee. Great, very easy to change. It's like a one-page document if that's still a change you're making. Or let's say, hey, I've named these beneficiaries. I want these 5 people to receive a benefit from my trust when I pass away. But something's changed, and I really just want 4 of them to get the benefit of my trust when I pass away. Very easy to make those changes in a revocable trust. And that's one of the great things about these tools is they're very flexible. Let's keep going here. I kind of talked a little bit about this already, but here's a graphic to kind of make it easy. That says grantor there. Grantor and settlor they mean the same thing. It's the person that creates the trust. They transfer assets into the trust, and then while they're living, they're the benefit of that trust. They're the beneficiary of that trust. They get all the assets that are there exist for their benefit. If you put your house in there, which is the most common thing, that's the deed changes a little bit, but otherwise it's still your house. You still pay the property taxes. You still have to pay the insurance and the mortgage and all that. None of that changes. It's only that after you pass away do assets go to your beneficiaries, family, friends, and charities. Okay, let's keep going here. All right, I'm just going to click all these things so I can talk about them. Cool. All right, let's talk about the concept of vesting. It's very important. What happens, unfortunately, very frequently, is someone will go to a lawyer or they'll work with their plan giving professional at their local conference, and they'll get these documents created, and they'll feel really good about themselves. Like, I went, I got it done. I've been putting it off for years, but I went and I saw the lawyer, and I gave him all the information he needed or she needed, and we got the documents, and they're here and they're done. Good job, me. Unfortunately, there's still a little bit of the work that needs to be done, because just having the documents by themselves is good. That's a good step, but it's not the last step. We have to go through the process of what we call vesting, which is making sure that your assets have been entered into your estate plan the right way. So the most common example of that is once you've created a trust, most people when they're creating trust and they own a home, they're going to be adding their house into the trust. That's by far the most common reason people get a trust, is so that the house can be disposed of per their instructions after they pass away without going through probate, excuse me. And so it's really important that you execute a new deed for your house that says, now instead of owning it as myself, Richard Harrison, it's now owned by Richard Harrison as trustee of the Harrison Revocable Living Trust, right? That's the only change that happens, is you have to execute this deed that just says, instead of owning it as Richard Harrison in my own name, I own it as Richard Harrison as trustee of the Richard Harrison Revocable Trust. And that's all that needs to happen. It's a change into the title of the ownership of the property, so that when I pass away, my successor trustee of the Harrison Revocable Living Trust, now he automatically becomes gets authority to deal with the house, per the terms of my trust, right? So whatever my trust says, hey, my successor trustee, when I die, I want you to sell my house and give the money to my kids. Now he has the authority to do that because he's already listed on the trust, and I don't have to go to probate for him to get permission to do that. So that's hugely important. Now, I mentioned the example of the house, but the same thing can be done with retirement accounts, investment accounts, other assets. Most of those other assets have a document where you can fill out a beneficiary designation form, and which says that when you pass away, those assets automatically go into the trust. Oh, sorry, it's muting to do here. There we go. So again, the point is, it's very important that once you've created the documents, let's go through the process of making sure the assets that you want to be disposed of in your documents can actually be disposed of, because they're going to go into the trust when you pass away. Okay, and your legal professional and plan giving professionals will absolutely be able to assist you with that process. Okay, I want to mention just quickly this term of pour over will. When we create a trust, we actually include with that a special kind of will. And the only thing that's special about that will is, instead of the will saying, when I die, everything goes to my kids, the will says, when I die, everything goes to my trust. And then my trust says what goes to my kids. Okay, so the will and the trust work together to make sure that your wishes are being followed accurately. Okay. I've talked about this in pretty good detail already. I'm trying to get through this stuff quickly so that we have time for questions at the end. But I've talked about modification of the trust, very flexible, absolutely can be changed. The estate planning process is not a one and done process. It's important to reevaluate your life situation every several years, 5 years, every 10 years at least, to make sure that the wishes that you documented 5 or 10 years ago are still accurate. And not only make your wishes change, but your financial situation changes, your life situation changes. And so it's important that your documents stay updated to keep up with what's going on with your life. Okay. And there is a situation where, you know what, I just need to scrap this entire estate plan and start over fresh. You can absolutely do that. Trustee duties. I want to talk a little bit about this just briefly. When you create a trust and give another person, a third party, the authority to act on your behalf after you pass away, they are bound by what we call fiduciary duties. You may have heard that term before. It's a very important legal word. It means that when a person is your fiduciary, they have legal obligations to act on your behalf. When you name a third party in your trust to be responsible for handling your assets, they absolutely cannot just party or run off with those assets with no legal repercussions. They have legal obligations to follow, and there's some processes that go along with that, and that's very important because obviously we want to be able to trust that when we've documented our wishes, that our wishes are being followed after we pass away. Um, but they're all that's a double-edged sword because it's important that we recognize that our third parties, our fiduciaries, the people that we trust with this, will also have responsibilities. And it's important to name somebody who we trust and who has the ability to fulfill those responsibilities to those roles. Okay, I'll talk a little bit more about that later, about how to choose a good fiduciary. Okay. And then another brief word about beneficiaries' rights. Uh, when you pass away, you're no longer there. You're no longer available to make sure that your documents are being followed correctly, right? So who is going to enforce those documents on your behalf? And the answer is your beneficiaries, the individuals that you have named as the people who have the right to receive assets from your estate plan. Those are the folks who have the legal right to go to court and say, hey, court, this person who is supposed to be handling my parents' estate, they're not doing what they're supposed to do. And so the law does give your beneficiaries the legal right to enforce the terms that are in your document. And that's very important. And I'm just saying all of that to share that you have to be able to trust that these documents are going to do what you expect them to do, and there are legal mechanisms in place to make sure that that happens. Okay. All right. Okay. I'm going to talk about this briefly, and then I'm going to go 3 or 4 more minutes, and then we'll stop for questions. Okay. As part of the estate planning process, it's not just, I've been talking a lot about what happens when you die, right? But perhaps even more important than that is planning for what happens if you can no longer make decisions for yourself, whether that's because of physical injury or because of mental illness, right? The estate planning process includes planning for incapacity. And so I'm going to go quickly through this. There are a couple different types of the documents. The most common are the durable power of attorney. That is a document that's created that says who has the authority to manage my finances and my assets if I am no longer able to manage them for myself. And then advanced healthcare directive is the word for it in some states. Other states, it's the medical power of attorney. Other states use the phrase living will. You might be familiar with that one. That's where you name a person who has the authority to act on your behalf for medical decisions if you're no longer able to make those decisions for yourself. Okay, those two things are also a very important part of the estate planning process. I literally met with an individual last week who has already spent thousands of dollars on estate planning documents for himself and his family. And I just asked the question, well, what happens? He's a business owner. I said, what happens if not if you die, but if something happens to you, like, and you're unable to make decisions for yourself, but you're still alive, what happens with the business then? Oh, didn't think about that. And it's very important to consider that as well. And you'll have an opportunity to talk with your legal and plan giving professionals about that. Okay, I'm going to skip some of these estate plans because I want to take some questions. I have a few questions that were given to me ahead of time, but I think it's already 6:50. Should we just skip to questions that have come in from individuals? If we don't get a lot of those, I can always do these.
Sure, Richard, you can take some questions from individuals first, and we are okay to go longer. We just want to finish our scheduled programming by 7, and then the rest is up to you if you want to stay later and answer more questions.
All
But we
right.
can start with some questions from our members. And I do see
Okay.
one that came in the chat here from Dorette. And this is a great question. She says, going back to pay on death accounts, if one tries to avoid probate by having assets pass via pay on death accounts, what are some possible tax consequences to the beneficiary who receives the money via a pay on death account? Asking because some people don't have enough assets to warrant paying for a trust, but are wealthy enough to need an estate plan.
Great question. And so the answer is it depends on the type of account. Generally, things like bank accounts, there's no tax liability for the money that goes from one person to another. If someone has a payable on death beneficiary on, let's say, your bank account, the money just transfers from your account to their account with generally no tax liability. An example of what the tax liability might exist is if it's an interest-bearing account, from the time that you pass away to the time where they take possession of the funds. If it accrues any interest, then that interest would accrue to them, and they know whatever normal taxes would be on that interest. But there are other types of accounts, like for example, your IRA accounts. That's a massive one. If it's not in a Roth IRA, if it's just a regular IRA, or if it's a 401k account where the funds were taken out of your paycheck pre-tax, right? So that means tax has never been paid on them. If you name your kids as just a straight up cash beneficiary on those accounts, then if they get paid out on that account in cash, in January of the following year, they're going to get a 1099 from that company saying, "Hey, you received all of this funds in straight income that has not had tax pay on it, and now you owe all of the tax on that money." So when it comes to retirement accounts specifically, some good planning is very important. There are strategies in place where an individual, if you want to give those funds to an individual, they have the ability to roll those funds over into a retirement account for themselves, which can stretch out the tax burden so they can take it over time rather than all in one lump sum. But there are some rules against that. A lot of those rules revolve around what age those beneficiaries are when they take possession of this account. If they're very young, they may have to take that rollover over a shorter period of time. Whereas if they're over 70, then they can stretch it over their lifetime. And those dates and those ages have changed a lot over the last 10 years. People are retiring later. You know how they keep moving up the Social Security date? Well, in the same regard, they've changed the ages on rollover IRAs and things like that. All that is to say, some proper planning is very important when you're dealing with, even just if you're trying to make someone a beneficiary of an account.
Great answer, Richard. Thank you so much.
Yeah.
So we have a few more questions coming into the chat. The next one is from John. How much does it cost to create a trust in general?
I'm sorry, I have to give you the very stereotypical lawyer answer, which is it depends. It depends on a couple of factors. The first is where you live. Unfortunately, lawyers in New York and California are much more expensive than lawyers in other states. Lawyers in the big city are more expensive than lawyers who are in more rural communities. So I can't answer that question with great specificity. I could say that to create a full trust package, which includes a revocable living trust, a pour over will for yourself and your spouse, essentially, and the powers of attorney documents that I described earlier for incapacity planning, the minimum amount that should be expected to be paid is roughly around $1,000. Now there are, ways to alleviate those costs, and this is where, my plan giving colleagues will pitch in and say, if you work with the conference, they have some programs to help you out with those costs. And so you should definitely talk to your plan giving professional. On the upper end, $4,000 is not unheard of, $5,000. And then if you could get even crazier than that, when you start talking about like Medicare and Medicaid and trust that people set up to, qualify for Medicaid and that kind of thing, those are in like the tens of thousands of dollars. But those trusts exist for people who have those assets who are trying to keep them around for their kids, and so they're trying to spend that money to avoid paying a bunch of taxes on the other end. So, but yeah, it's not a cheap endeavor, that's for sure.
Yeah, thank you, Richard, for giving us some ideas there. And he's right. You can absolutely reach out to your local plan giving office, maybe to get some ideas of what you might have to pay or to ask about our programs that we have in place to reimburse members or in some case offer free estate planning services. So make sure you reach out to your local plan giving office. Our next question is from Edwin. If we have a revocable living trust, do we still do our taxes as an individual? I think he means, are there trusts that have to do their taxes separately?
Generally, okay, this is a very general answer, okay, because it depends on the type of the trust, depends on the type of tax, and depends on your assets. Generally, though, for a standard estate planning revocable living trust, the trust is not treated as a separate taxable entity until after you pass away. Uh, Generally, you don't even file a separate tax return for the trust until after you pass away. The IRS sees it as a pass-through trust. You don't have to get a separate tax ID number for it. You don't have to file a return for it. You just file your taxes normally, and generally, like in most cases, you don't even get any tax documents at the beginning of the year that have the name of your trust on it. In every state, there is legislation that has been passed that says that they don't treat property tax any differently than if you have your property in your own revocable living trust versus if you have in your own name. They're not allowed to change your property tax. I'll tell you, I've seen it happen where we've executed a deed to put the property from in the name of the individual into the name of the trust, and the county will say, "Oh, you had a change of ownership, and we're going to reassess your property tax, and now you're going to pay more property tax." And we've had it reversed every single time. They're not allowed to do that. Um, and yeah, so that's the general answer. Now, that being said, there are specific cases where the trust is. Hold on, someone's beeping at us. There are specific cases where we set up a trust on purpose to create a separate taxable identity. But in most cases, that doesn't happen for your standard estate planning purposes.
Okay, thank you so much, Rickard. One quick question, I think, before we get to 7 o'clock. When does the durable power of attorney take effect?
Great question. That's entirely up to you. In most cases, what most people choose to do is to have the power of attorney take effect when you become incapacitated. As a reminder, the power of attorney is the document that says who gets to make decisions on your behalf if you can no longer make decisions on your own behalf. So most people set up that document so in such a way that it sits there and does nothing while you're alive and while you have full capacity. But then if something happens, whether mental illness or physical injury causes you to lose the capacity to make decisions for yourself, then the document springs into action, and the individuals that you have nominated have the authority to come in and make decisions for you.
Thank you, Richard. That's great. Okay, so we are just about at 7 o'clock. So I want to respect everyone's time and keep it to an hour. So we will pray to close. And then, Richard, I don't know if you're busy and you need to leave, you'd be welcome to stay and answer the rest of our questions
I'm
if you
happy to
want.
hang out and answer
Okay.
questions.
So I'll pray to close quickly, and if anyone has to go, you can. And then for folks that want to stay around and ask a few more questions, we'll do that. All right. So please bow your head. Dear Heavenly Father, thank you so much for this wonderful presentation we had this evening. And we want to ask a blessing upon everyone here that you would be with them and encourage them as they go on their estate planning journey. And please bless our presenter this evening. We're so grateful for his knowledge and for all here. Please grant them traveling mercies if they're traveling. And I pray that you would go with us into the rest of our week. In your name we pray. Amen. All right. Thank you. Richard, can you change the host to me real quick just so I can remind everyone of a few things we have coming up?
All right, let's go to John Casey from Waterford, Michigan. So you're known as what? I'm known as a.
Yeah, well,
Okay, thank you so much, Richard. And I just want to share with all of you before you leave that we do have a few more webinars coming up this year. You can see them all on your screen now, but our next one is going to be April 28th, What to Do When You Say I Do Later in Life. And this is focused on blended families, couples getting married later in life that need estate planning advice related to that. And you can contact your local conference with the information on the screen. This is for the Florida conference. If you want to learn more about estate planning, if you want to learn how your local conference can help you with it, we have a lot of wonderful services, as we mentioned in the beginning. So I hope this presentation got you thinking about ways that you can plan to protect your family. So you can take a screenshot of this or use the QR code to contact the Florida conference if that's your local conference. And then we also have other conferences here supporting Georgia, Tennessee, Kentucky, New Jersey, and Southern New England. So I'm going to leave these on the screen just for a few minutes for anyone who wants to take note and be able to contact those conferences. So if for those that are asking, we will have a copy of the recording available online, and you should get an email from your local conference about that. And we can also share the PowerPoint with you if you request.
QR code, please. Go back to the QR code.
Yeah, I can go back to the QR code. 1 second. All right, so we did have a few more questions in the chat, Richard, if you have a moment to answer them.
Yeah, I can see them.
Okay.
Very simple. Yeah. Okay. If we have a revocable living trust, oh, we did that one. How do we leave money for Christian education for, oh, I'm sorry. I'm going to do this in order.
That's okay.
Yeah. Do you put your retirement account in your trust or do you make your trust the beneficiary? That's a great question and it's a long answer. I'm going to try to go through it quickly. Again, like stereotypical lawyer answer, it depends. Generally, I would say the best advice is not to name your trust as the beneficiary of your retirement account, because the rules about the way the trust has to pay out the funds are not the most ideal for the tax liability that comes with retirement accounts. Now, that being said, there are some good reasons why you would want to name your trust as a beneficiary. The first is if you are planning on doing some significant charitable giving with your trust, one thing, and you have other significant assets that don't have tax liability. I'll give you an example. We're talking about an estate that has some real estate in it that can be transferred without tax liability, and also has an equivalent amount of retirement assets, equivalent value of retirement assets. And you know you're going to be leaving, let's say 25% of your estate to charity. The idea is let's use the high tax assets to give to charity and the low tax assets to give to your kids. That's the strategy, right? So you can work the trust in such a way so that you use the trust to funnel the high taxable assets to your charitable beneficiaries and your low tax assets to your kids or your individual beneficiaries. So again, the answer is you need to talk to a legal professional who is familiar with this kind of stuff. And I'll say there are legal professionals out there who do estate planning work who don't really work with charity at all. And we're all here, we're all church employees, so we work charity a lot. But uh, some it's important to have at least a legal professional who knows the charitable aspect of things, so that they can work with you if you have those high tax burden assets, and to help you, um, dispose of those in a way that leaves the most non-taxable assets to your kids. If But in some cases, especially if you don't have any charitable intent, then it's usually better just to name your kids as a direct beneficiary of those IRA assets, so they can roll them over into their own IRAs for later in life. But again, depending on the age of the kids and your age and the tax liability that's attached and the type of retirement account that it is, that's something that you want to review with a professional to make sure that it's done the right way. Okay.
That's great. Thank you so much, Richard. We'll give a minute or two if anyone else has more questions, if they want to put them in the chat, or if you raise your hand, I'll be happy to unmute you and you can ask. I do want to point out that Andrew and Jennifer were mentioning about the durable power of attorney question, that you should be sure to check your state, consult an attorney or call your plan giving office to ask about when those durable powers of attorney take effect, because it can vary a little bit in different states they were sharing. So thank you for that, folks. We have another question from Edwin. What do you do if you have several houses in 3 different states? Do you make one trust to cover all the houses?
Generally, yeah. The way that works from a legal perspective, so real property, the land, states have an interest in governing the land in their state, right? Each state wants to make sure that the land in their own state gets, handled the right way and in their own way. So the way that works is generally, the state that you live in when you pass away will kind of, will usually be the where your estate gets handled. And then, assuming that you've placed all 3 houses into a trust, it's really easy. Your successor trustee can go to each a realtor in each state and sell each house. No big deal. There is a document that the successor trustee has to file in each state that says, "Hey, I'm the guy in charge of this estate, this trust now." But once that's been done, then your successor trustee has the authority to go in and sell all the houses if that's what the trust calls for them to do. If you don't have a trust, then what ends up happening is you have to go do a probate in each state. And that could be challenging. Specifically, like, you might have retired in Florida, but if you still have that house in California, good luck. And so, yeah, so it's another example of where a trust can really, really be helpful, because it's a much shorter process and much less paperwork, to go in and dispose of all of those assets. But it can be done. You'll have a primary probate in your primary state where you passed away, and then there's a process called ancillary probate that happens in the other states where the property is located. And that's usually how that works.
Thank you, Richard. That's really helpful. So we definitely want to be mindful of trust if we have properties in multiple states. That could be a great
Absolutely.
benefit. Okay, so I think Jennifer's just drawing attention to, did we need to answer the question from Lou and Connie, how would one leave money for Christian education for grandchildren in a trust? It sounded like you were touching on that a bit, but did you answer that question separately?
Yeah, I saw that
Apologize
one.
for-
I'll be brief.
Okay.
It's as simple as when you talk to your plan giving professional and we talk to your legal professional, you just let them know, hey, I would like to leave money for Christian education for my grandchildren in a trust. And they'll talk about the different ways that you can do that. There's a couple of different options. One is creating what's called an education trust, that pops into existence after you pass away, where the money is held, for the benefit of your grandchildren or for anybody that you want to make it for. And when they become of age and they go to school, they tell the trustee, I'm going to this school, and you could put language in there that says they have to go to Adventist school, Christian school, you are in control of the criteria that exists there. And you can, and then when they're ready to go to that school, they call up the trustee and say, hey, I'm ready to go to school. And the trustee sends money, usually directly to the school, to pay for their education. But that's just one example. Like I said, the trusts are incredibly flexible documents, and the professional that you work with will have a conversation with you to determine exactly what your wishes are, and then craft the documents so that you can determine who holds the funds while they're waiting to go to school, what the funds can be used for. You can set up uh, things like scholarship funds with the school directly. There's so many different options that can be done. And so when you talk to a professional, they'll work all through all that stuff with you.
Thank you, Richard. So we do have 2 more questions that popped up. I want to answer those. And then for anyone else that has questions, I'll encourage you to reach out to your plan giving professionals for your questions. We can also connect you with Richard if you have questions about his presentation. And we're really grateful, Richard, for your time and you being here today. So I don't want to keep you too much longer. But if you can answer a quick question from Anna and Clifford and Sue. So Anna says, does a trust have to be financially supported and what is the best way to do it? I think she'd be referring to funding a trust, right?
I think so. So generally, a revocable living trust does not have to be financial supported. In fact, there are many examples of trusts that exist that don't have any assets in them because, as I mentioned before, either they never went through the process of adding assets to their trust, or they set up a trust, put the house in it, and then a couple years later they had to refi the mortgage and they pulled the house out of the trust to do the refi, and then never got around to putting the house back in the trust. See it all the time. Um, and so yeah, so a trust, we call them empty trusts, we call them dry trusts. They can exist without any financial support on their own. Generally, yeah, it doesn't cost any money to maintain a trust while you're living, because again, the legal system doesn't treat it as separate from you. It's just on paper. And so, um, so no, a trust doesn't have to have its own financial support while you're alive. Now, when you pass away, if you have like some sort of complex distribution scheme where money is being held in an account for the benefit of other people for 20 years after you pass away, and it needs to be invested, and that kind of thing, that stuff exists. And then, you may end up needing to set aside money to be used to pay for somebody to do all of that stuff for 20 years after you pass away. So in that situation, a trust does need financial support. But for the purposes of our conversation today, I think the answer is no.
Great, thank you. And then our last question from Clifford and Sue, I think you touched on this a little bit. They're asking, are documents done in one state valid in other states after you move? And it sounded like you were saying the answer is yes, but you might have to probate in different states if you only have a will. Anything you want to add on that?
Yeah. I mean, the answer isn't a resounding yes. It's the typical answer. It
Depends.
depends. Yeah. So the way that generally works is each state has its own rules for what constitutes valid estate planning documents. And as long as the documents that were created in one state would also meet the rules of the other state, then generally the new state will recognize it as a valid document. For example, I know some states require a will to have 2 witnesses when it's signed. There are these formalities that come with with formal wills, and other states may only require 1 witness for a signed will, for a formal signed will. So if you move from a state that requires 1 witness to a state that requires 2 witnesses, then that will would not be valid in the second state. So if you do make a move to a new state, it's important to have a conversation with a professional in that new state who can look over your documents and verify that your documents will continue to be valid in your new state.
Great. Thank you so much, Richard. I think that is all the questions that we're going to take. Thank you everyone for being so engaged. I have never been at a seminar 15 minutes over where there's still 50 people asking questions. So thank you for your excitement on this topic. And thank you, Richard, for giving such wonderful, detailed answers and sharing so much great info with us. And thank you for being a wonderful co-host of my Zoom with me as well. I really appreciate
You
your
got
extra
it.
effort tonight. So thank you everyone for being here. Yes, say thank you in the chat to Richard. We're very grateful for him. And please reach out to your local plan giving professionals. You can just call your conference office if you didn't save our contact info, but we're very happy to help you. As you can hear from this presentation, there's a lot to this topic and it can be nuanced, but you can do it. We're here with you and we're very happy to take your questions. So please reach out to us. And thank you all so much for being here. Richard, thank you again. And I hope you have a wonderful evening.